And joining me now is the first of my special guests, Justice Madan Lokur, former Supreme Court judge, joins me at this moment. Appreciate your joining us, Justice Lokur. Let's turn to this Arvind Kejriwal case. The Delhi liquor policy scam, as it's being called, the investigations began in August of 2022. Arrests were made in September, October. We are now in April of 2024. Mr. Kejriwal has been arrested, sent to 15 days judicial custody, and the ED says they sent him 8 summons which he did not appear before them. So he's been arrested. There are approvers there. They claim they will have a chain that will link Mr. Kejriwal, whom they call a mastermind. How do you see this case then? As a possible excess of power, abuse of power by the ED, or, as the ED is claiming, a necessary step to prevent money laundering and crack this case?
Well, I think this is, an exercise that has been taken by the Enforcement Directorate in excess of its powers. You see, for example, you say in August 2022, the whole thing started, right? So we are almost 1.5 years down the line. Now, is the Enforcement Directorate trying to say that, listen, we've not been able to complete the investigation in 1.5 years, in spite of the fact that they've put in Manish Sisodia inside for such a long time, all right? So what is it that is preventing them from completing the investigation? If they have the material, why are they not in a position to file the charge sheet? Why is it taking them so long to figure out what to do, right? And what is the material on the basis of which they have come to the conclusion, or the authority has come to the conclusion, that Mr. Kejriwal should be arrested?
Sir,
and if that material was in existence earlier, why didn't they arrest him earlier?
Why didn't they arrest him earlier? You see, the argument the Enforcement Directorate is making, Justice Lokur, is they've gone step by step. They've arrested various individuals and have built a chain that links the so-called Southern Cartel of distillers with the Delhi government and payments made. They've got approvers in place. And as I said earlier, they've sent 8 summons to Mr. Kejriwal starting in October 2023. So when there are people who are questioning the timing and saying, why arrest someone just before an election? The Enforcement Directorate is turning around and saying, look, we've been trying to get summons and question him 6 months ago, and we've carefully crafted this case step by step. None of the accused have got bail, not even Manish Sisodia.
Well, first of all, I think, the accused should have got bail, right? Why are they being kept in jail? Mm-hmm. Okay, that is the question that has to be asked. All right. Mm-hmm. Now, I think the law is fairly well settled that if you are going to tamper with the evidence, or you are going to, influence the witnesses and so on, is there any material that Manish Sisodia, for example, is going to tamper with the evidence, or that he's going to influence witnesses? If witnesses had to be influenced, Arvind Kejriwal could have done that much earlier. All right. So what is it? What is it that is compelling the Enforcement Directorate to demand their arrest? And what is it that is compelling the courts to say that, yes, these people should continue to remain behind bars? Now today, for example, it is said that Mr. Kejriwal is uncooperative. Well, what do you expect him to do? What do you expect any accused person to do? They have a constitutional right to remain silent. Mm-hmm. All right. So after you arrest a person, you can't ask him to, confess to everything unless he wants to.
Justice Lokur, let me just stop you for a moment. You say you are surprised that bail has not been granted and they've all been sent to jail in this case. This is where I come to a critical point, that the Prevention of Money Laundering Act, as it is drafted today, is being seen by many legal luminaries as a draconian law. It has reversed the entire basis of bail, not jail. The Supreme Court had said in the state of Rajasthan case way back in 77 that bail, not jail should be the rule. It's now effectively been reversed in PMLA to jail, not bail. Does that make in a sense? Is PMLA the problem? Or is it the Enforcement Directorate, or whoever is allowing the Enforcement Directorate to weaponize PMLA, which is the problem?
Both. You see, it's not mandatory. It's not mandatory that you have to arrest a person, right? So when you arrest a person, okay, the law says that he has to, prove his innocence. All right, that's a draconian aspect. That's a question of reverse onus. All right, which is draconian, because the normal presumption is that a person is innocent until proved guilty, but here the onus is reversed. That's one draconian aspect. The second aspect is the procedure. Why are you arresting him? I mean, are you arresting him because you have the power to arrest? If that is, the explanation, then I'm sorry, it can't be like that.
But may I say, Justice Lokur, that it is the Supreme Court itself which in July 2022 ratified many of these very provisions of the PMLA that have virtually given the Enforcement Directorate the kind of powers that they can go ahead and do these summary arrests, some on mere suspicion, some would say, but with reasonable belief. So in a way, and that judgment has not been reviewed till date. Even the Supreme Court has said it will review it. We are now in 2024, and the bench has not even met to review that critical judgment on PMLA.
Yeah, you see, Rajdeep, mere suspicion is not good enough. The law says that the arresting authority, that is the deputy director or whoever it is, must have reason to believe that the person has committed an offense, right? And the expression reason to believe is justiciable. So it's not just suspicion. Suspicion is not reason to believe. There has to be something much more on the basis of which you're arresting a person. So in that sense, it has been weaponized. The law has been weaponized, where you just say that, well, I suspect that you've done some, offense, so therefore I'm arresting you. But it's not like that.
Sir, but the word reason to believe under Section 19 of the PMLA, which allows the Enforcement Directorate to arrest someone because they have reason to believe that he has committed the crime of money laundering with a very wide range of predicated offenses. Do you believe that given the nature of these words, we need greater clarity? And this must come from the Supreme Court itself. Otherwise, this phrase will be misused to arbitrarily arrest people in different cases.
Yes, it is. We do need clarity. You see, the expression reason to believe is not a new expression, right? It's there in the Income Tax Act, and you will find 100 judgments on what is the meaning of reason to believe. It is not subjective, all right? It is objective. So when the authority says that I have reason to believe, it has to be an objective reason to believe, which has to be put down in writing. Okay. Now, that reason to believe, if it's a sort of a make-believe kind of reason, the expression reason to believe, the reasons are justiciable. Under the income tax law, reason to believe has been challenged, and assessees have succeeded in showing that there is no reason to believe.
Sir, let me make the most direct question now. Is, in your view, as a retired Supreme Court judge, the Enforcement Directorate being misused through the PMLA to settle scores by the government of the day with political opponents? That's the fear that the opposition expresses. The government says you're looking at only a fraction of the cases being prosecuted by the ED. There are a number of cases which involve businessmen where their assets are being seized. Why only focus on politicians? So do you see the ED being misused to target political opponents of the government like Mr. Kejriwal?
It appears to be so. It appears to be so. There are circumstances on the basis of which it appears that only some persons are being targeted.
That's a very serious charge you're making, but what then for you is the solution, Justice Lokur? Because if that is is the case, the Enforcement Directorate and its powers are being weaponized, what is the solution to ensure that there is no miscarriage of justice and an individual's personal liberty is not compromised when he's sent to jail?
Well, one is, I think, the Enforcement Directorate would have to be reined in, right? you cannot weaponize a law just because the law is there. Second, I think the courts have to be far more vigilant that the procedures that are there in the law are being followed. Okay? Now, once that is done, the sting in the law will probably disappear. It appears to me that the courts are not following fully the procedure that is there in the law, or not demanding from the ED that you follow the procedure.
But sir, in the Arvind Kejriwal case, the ED is arguing that they believe he's the mastermind, he's the chief minister of a state, so he is in a position to tamper with evidence. That has been their argument in court.
Okay. Now, the Supreme Court has also said that since you believe that a person is going to tamper with the evidence, or the person is likely to influence the witnesses, it's not good enough. On what basis are you saying that you believe that this is going to happen? I mean, anybody can tamper with evidence, anybody can tamper with witnesses, right? So merely making that allegation is not good enough. You have to have some basis for coming to the conclusion that this person has attempted or has in fact tampered with the evidence.
But Justice Lokur, there is also talk of vicarious liability in this case, where the Aam Aadmi Party as a political organization, according to the ED, could be held liable and could be accused in a charge sheet. Do you see that again as a potential excess to virtually cut a political party out of our system by charging them under the PMLA?
No, I don't think so. This kind of vicarious liability in criminal law, in a situation like this, I don't buy it.
So there is no. You're saying you don't buy vicarious liability. In conclusion, with the possibility, sir, that Mr. Kejriwal could now spend an extended period in jail, may I ask you, do you believe that a government can be run out of jail, or will the courts have to now intervene and set some guidelines in your view?
Well, I think constitutional morality requires that Mr. Kejriwal should quit. All right, that's constitutional morality. But, well, if he chooses, that I don't care about constitutional morality, I'm going to run the government, there's nothing to stop him. So many people are violating, constitutional morality. Governors have been accused of violating constitutional morality. So if he says I'm going to violate it, so what?
But do you believe at least that expeditiously, at the very earliest, there should be a judicial review, sir, of the PMLA judgment that is hanging fire since July 2022? You will recall, sir, in September last year, certain political parties went to court, opposition parties, and said, give us protection against the misuse of the law. Court said we can't treat political parties separate to individual citizens. Do you believe there should be a review of the law that will protect not just politicians, but every citizen will be ensured that his or her civil liberties are protected and the PMLA is not misused?
Yes, I think it should be done immediately. The review should be done immediately. The whole issue has to be looked at in the perspective of the Constitution also. The right to silence, that's a very, very important right, which is not being enforced, in the sense that the directorate keeps saying not cooperative. I mean, you don't expect an accused person to cooperate. What are you there for? I think the whole thing has to be looked at all over again.
Can I though put you on the line, Justice, and say, if you were in the judge's place now, would you give Mr. Kejriwal bail based on the facts that are available before us in the public domain?
On the facts that are available in the public domain, yes, I think a strong case has been made out for bail. Yes.
Mr. Justice Madan Lokur,
yeah, but let me be clear about one thing. There might be something more which we don't know. All right. But from the facts which are available in the public domain, I think he deserves bail.
Okay. Justice Lokur, for answering all my questions and answering them so candidly, thank you very much for joining me here on the news today.